May it please the Court, I am Jacob, initial A, representing the respondent Mr. Ray Givens in these proceedings. The respondent seeks to lodge his formal objections to the affidavit filed by the applicant, Mrs. Givens, in line with the Evidence Act 1995, Commonwealth, Section 4, Subsection 1. I will refer to the Evidence Act as the Act. We submit the respondent has no objections to paragraphs 1, 2, 3, 6, 9, 10 and 11, as they comply with sections 55, subsection 1 and section 56, subsection 1 of the Act. We submit that the respondent's objections to the following evidence is on the grounds that it is inadmissible according to section 56, subsection 2. Our objections are supported by Smith v. the Queen, whereby evidence without a logical connection to the property pool, the parties' financial contributions, or their future financial needs is evidence that must be struck from the affidavit. Paragraph 4 contains allegations that Ava is a user of ice for drug offences. This evidence is irrelevant. Paragraph 5 refers to the applicant's career before the relationship commenced. As paragraph 6 addresses the applicant's income, this evidence adds no probative value. In paragraph 7a, the objection is in reference to the previous boyfriend. Paragraph 14 compares the Daintree property with the applicant's sister's property and sale price. This holds no probative value in determining the current market value of the party's property. In paragraph 19, the applicant states should be factored in as property retained by Ray. This is for the court to determine, not evidence that can be adduced by an applicant. We now turn to the hearsay rule. We submit the respondent objects to the following evidence which violates section 59, subsection 1 of the Act. We rely on Submaranium v. Public Prosecutor and Cullen v. Clark for our objections. Paragraph 8 relies on Ava's statement to prove the existence of a drug debt. This is hearsay and irrelevant. Paragraph 13 contains double hearsay. The applicant repeats what Wendy was told by their parents. As Wendy is not testifying as a witness, section 64 cannot be applied. Paragraph 15 contains two out-of-court representations, one made by a real estate agent and the other by the applicant's friend. Both were relied on to establish the approximate value of my client's property. We now turn to the hearsay exceptions. We begin with the evidence adduced in annexure and note section 59, subsection 3 serves as a signpost to direct us to the business records section in section 69, subsection 1. We also note Part 1 defines a document as any record of information, photographs, or electronic records. The respondent raises no objection to WG1. However, we note its inconsistencies between the opening balance in paragraphs 19 and in WG1. We also note the inconsistency with the dates that the money was transferred against the date of separation in paragraph 3. The respondent seeks a limiting direction order under section 136 to reduce the risk of any unfair prejudice or confusion. WG2 is an exception under section 71. However, the respondent objects as it was adduced with malicious intent. If the court is satisfied it was improperly or illegally obtained, the respondent will seek that paragraph 20 and WG2 be struck from the affidavit in accordance with section 138. The respondent objects to WG3. It is a letter prepared and obtained in connection with a court proceeding. Section 69, subsection 3a states that section 69, subsection 1 cannot be relied on in these circumstances. Moreover, the applicant violates the hearsay rule by inconsistently repeating Mr. Mullen's representations within this letter in paragraph 21. WG4 is accepted as a document. However, the respondent objects as it was taken by a third party to prove a fact about my client's health. The respondent objects to the evidence adduced in paragraph 22, as it fails the strict first-hand knowledge threshold set out in section 62, subsection 3. Therefore, section 66a will not apply. The respondent seeks an order for WG3 and paragraph 22 to be struck from the affidavit. Your Honour, we turn to the respondent's objections of paragraph 12 and 17, as they breach the no prejudice protections in section 131, subsection 1 of the Act. Paragraph 12 discloses matters arising from mediation. This communication is protected under subsection 1A. We rely on Phil v. the Commissioner for Railways, New South Wales, whereby the parties must be free to negotiate without fear that their discussions will be used in evidence. Paragraph 17 discloses the contents of a letter prepared by a lawyer in connection with legal advice and dispute settlement. We submit this evidence as afforded protection under subsection 1B and is subject to the legal professional privilege under section 118. The respondent seeks orders for both paragraphs 12 and 17 to be struck from the affidavit. We submit that the respondent does not object to paragraphs 16, 18, 22 and 23 on the basis that they satisfy the admissions exception in section 81. The respondent does object to the adverse inference, however, against my client's silence in paragraph 19. We rely on Young v. Tibbetts and section 128 to support our objection, whereby silence alone cannot establish the existence of a fact, that being a drug debt. We submit paragraph 11 falls within the exception of a representation made by an unavailable person. Therefore, the respondent does not object to paragraph 11. Your Honour, I now turn to the adduced opinion evidence which the respondent objects to in accordance with section 76 subsection 1. We submit this evidence also fails to meet the lay opinion person exception in section 78. In paragraph 4, the applicant states that Ava was a frequent user of drugs with offences. These are speculative opinions which are prejudicial and irrelevant. In paragraph 5, the applicant describes her career as promising and claims to have had a large online following. These are subjective assessments that do not assist the court in determining the contributions of the parties. In paragraph 13, the applicant repeats her parents' opinions. This is speculative evidence provided by third parties. We submit the respondent also seeks an order for paragraphs 4, 5 and 13 to be struck wholly from the affidavit. In paragraph 7, the applicant describes the Tesla as a top-end model and owning a significant volume of personal belongings. These are vague and subjective descriptions which may not pass the layperson opinion rule in section 78. In paragraph 8, the applicant asserts that the respondent was wasting marital assets to repay a drug debt. This allegation is speculative and contradicts the evidence in paragraph 19, whereby it is alleged to be deposited for Ava's birthday. In paragraph 19, the applicant states that my client transferred money to what she believes is Ava's account. This may fall under the exception of section 78. As it corroborates with the material found in WG1. The respondent seeks a limiting direction order under section 136 to reduce the risk of unfair prejudice or confusion pending from this paragraph. We now turn to the specialised knowledge exception in section 79. We rely on Honeysett VR to support our objections, which require substantial adduced proof of knowledge, specialist knowledge. Furthermore, we rely on Makita v. Sprowls, whereby evidence must be demonstrated to demonstrate proof of identified body of knowledge, expertise, stated prime and proven facts, a logical chain of reasoning, and a direct logical connection to the fact and issues. In paragraph 7, the applicant estimates her Tesla at $120,000. However, the applicant has not demonstrated any specialised knowledge in vehicle valuation. We note paragraph 7's inconsistency with the agreed to valuation in paragraph 18. In paragraph 14, the applicant estimates the Daintree property to be worth about $400,000. The applicant does not possess the specialised knowledge necessary to provide a property valuation. The applicant also states that the property is largely unusable and connecting services would be very expensive. These are subjective opinions unsupported by evidence by a professional land surveyor. In paragraph 15, the applicant relies on a valuation for my client's Brisbane property by a Ray White real estate agent. No evidence has been adduced establishing this agent's qualifications nor her friends down the street. Finally, we return to paragraph 21. The applicant reduces medical opinions to prove a fact about her own mental health diagnosis and her capacity for employment. The applicant cannot adduce evidence regarding her own diagnosis. Additionally, this evidence is inconsistent with the evidence tendered in Mr. Mullen's affidavit labelled AM1. The respondent seeks an order for paragraph 21 and WG3 to be wholly struck from the affidavit. We now turn to the Court's attention to the filed affidavit of Anthony Mullins. We submit the respondent objects to Mr. Mullins' affidavit an annex of material labelled as AM1, as the material violates Section 59, subsection 1, and fails to meet Section 79. We rely on Section 177, Whitehouse v. Jordan, and Makita v. Sprouse to support our objections. While Mr. Mullins identifies as a psychologist, he has not adduced any expert certificate with his affidavit. Furthermore, his evidence is not independent and is reliant on hearsay. He fails to provide any prime or proven facts or any objective reasoning as to why the applicant should not work for the next 10 years. Mr. Mullins also fails to demonstrate a chain of reasoning to support how he concluded his formal diagnosis for the applicant after only 3 appointments. We respectfully seek an order, Your Honour, for the Court to apply Section 135 to all of our objections of the applicant's affidavit on the basis that the probative value of the adduced evidence is substantially outweighed by the danger it is unfairly prejudicial to my client. It is misleading and will result in an undue waste of Court's time. If it may please the Court, that concludes my client's formal objections. Thank you.